Right, I think this is who we are. Everyone's here is going to be here. So we'll get started. I feel like I'm a minister in church. Everybody up the back of the church. And the reason that I have to retire is that at lunchtime I went over to the office to get my glasses and did everything else but bring my glasses back. So it's time to go. So what we're going to do this afternoon is just have a look at the authorisation requirements in South Australia. And because that'd take us about 3 minutes, I wanted to actually talk about some other things that I think impact on best practice for organisations in their work with people with complex behaviours. And I think if organisations do these things a bit differently with the safeguarding arrangements that we've got in place through the Commission, I think we're going to see people with complex needs do much better than we've dealt with them in the past. So why do we take restrictive practices seriously? And I always like to start with Magna Carta. No free man can be seized or imprisoned without the judgment of his equals or the law, or by the law of the land. And the principles exist to this day. Nobody can be deprived of their liberty unless there's a legal process to do that. The other reason is that restrictive practices are dangerous. So in America, a Connecticut newspaper did a review of the deaths that occurred as a result of restrictive practices over a 10-year period, and they found 142. They believe they got 10% of them because a lot of these things were not even reported, let alone examined. And these deaths occurred when people were grabbed, taken to ground, a whole array of things. As I'll show you later, for sometimes not terribly important reasons. And we dress restrictive languages up in some, in some fancy language, seclusion, chemical restraint, mechanical restraint. But we need to remember that unauthorised restrictive practices constitute the crimes and torts of false imprisonment, assault and battery. And I've just gone through those three. I don't need to do that in a great deal of detail, except to say that the courts take it seriously. So when Cornelia Rao was falsely imprisoned, or found to have been falsely imprisoned in 2004, it cost the Commonwealth Government $2.6 million. So the courts take these infringements of rights very seriously. And just a historical perspective, people with disabilities have been locked up without consent that constituted false imprisonment. They've been physically restrained. That was battery if it wasn't approved, and many of these things weren't approved in the past because there's no mechanism to do it. People were restrained with physical restraint, straitjackets, etc. Again, that was battery. And there are a cohort of women in South Australia, probably aged 55 to 85, who 40 to 45 years ago, were sterilised, not only without their approval, but often without their knowledge of what was actually happening to them. And I like to reflect on how did this occur? And I think it's because, we did an assumption that there's us, the citizens of Australia, who deserve the rights and protections of our common law, and there are these other people. And once we make that distinction, we could think that it was okay to do these things. But indeed, these rights and freedoms did apply to people with disabilities. They weren't implemented and recognised. And the United Nations Convention doesn't sort of confer new rights on people. It basically says people with disabilities have the same rights as other citizens of Australia. So restrictive practices, I'm not going to go through this in a great deal of depth. Suffice to say that in South Australia, our definitions are now the same as the definitions that the Commonwealth uses. So physical restraint, if anyone wants any explanation, I'll just flick through these. I think most people know most of this stuff. If you've got any questions, just ask. Mechanical restraint using some device. seclusion, where basically someone gets locked in their room. Chemical restraint, where we use medication to basically control behaviour, often zonk people out. You'll see people in their bean bags almost immobilised. Environmental restraint, where we change the environment. The big ticket one is putting locks on refrigerators or on doors in a particular room. One of the things that we have in South Australia is just a little bit of a twist on this, and that is that there are some things which on the surface may appear like for example, a mechanical restraint, but which are not, because they're for a safety or a therapeutic reason. So somebody's got a splint on their arm to stop them from hitting their head. That is a restrictive practice. If somebody's got a splint on their arm to aid the healing process, that's not a restrictive practice. Except if the person objects either by saying, take this off, I don't want this on, or they're tearing at it to try and get it off, then to keep it on is actually using a degree of force, and when you use force, it has to be authorised, because no free man or woman can be restrained without due process of law. Now, one of the things we'll have to discuss is that a restrictive practice, or is that the use of force to impose a safety issue, and we'll need to just get some rules around that. These are the sort of things that are emerging as we meld this stuff into the Commonwealth arrangements. And again, the same thing occurs with chemical restraint. The drug that you might use to zonk people out is the same drug that you might use to treat a mental illness. What's the purpose of that drug? Now, there's a list of restrictive practices which we say shouldn't be used. They're probably prohibited. And if these were used and organisations were aware of them, they would constitute reportable incidents. And these include things like not letting people participate in an activity, or excluding them from decisions that they might usually be involved in. Not to be used in South Australia. I've missed one. Let me see if I'm smart enough to go back. Oh no, heavens, what have I done? Right. Aversive techniques or interventions. Now, in the old days when people were locked up in the back wards of psych hospitals, touched a doorknob that you're not supposed to touch, you got whacked across the knuckles with a bunch of keys. It did two things. It stopped you from touching doorknobs, but it also made you scared of keys. And it's just interesting. One of the guys who was in the back wards of Glenside Hospital, now almost 60 years ago, was living in the community in a house up near Kadina, and he was still really nervous about having keys, after all that time. So these lessons run deep, and we need to make sure that we don't use aversive techniques. I was almost not going to put this slide in because I thought that was all in the distant past, but about 3 years ago I came across a situation of a woman puffing somebody in the face with water in response to some behaviour, not even knowing that it was an intervention that she shouldn't be using. It was battery. You're not allowed to use anything like that. Your hand, a baseball bat, or a puffer of water. And we're saying in South Australia those things are unacceptable. And again, in the new environment on 1 July, these are reportable incidents. Psychosocial restraint, probably the big ticket one, where we use power to basically boss people around, ranging from yelling at people through to being manipulative and wheedling. And we see a lot of that, and again, these are strategies that shouldn't be used. It's interesting, every now and then, I was the after-hours service of our organisation for many years, and you get people ringing saying, I'm going out tonight, should I wear a red dress or a blue dress? And obviously what was happening is that these decisions were being made by other people. No use asking me. One, I'm colour-blinded, and you can see that I've got no fashion sense. But, it was interesting how even those small items of people's lives are being controlled, rather than people saying, look, you're going out, you make a choice. And, some of this was because we thought we knew better. There are some physical restraints that in South Australia we're saying we do not use. Prone and supine restraint. What this doesn't show, of course, because of my limited technical ability, is 3 bodies sitting on top of these people. They're dangerous, and we're saying that in South Australia they shouldn't be used. Now, when we're thinking of using a restrictive practice, the very first question that should be asked is there a legitimate reason or purpose for the use of this restrictive practice? So if somebody in the house is eating the frozen chicken, that might be a good reason to think about putting a lock on the refrigerator. If somebody from time to time spills milk on the floor, that's not a good enough reason to put a lock on the refrigerator. Now, you know, you think that I don't need to say this, but I've seen locks on refrigerators for things that are more like the spilt milk than the frozen chicken. And just to give you an idea of this, in America, in that survey of 142 people who died, the first person on that list of 142 people was a 15-year-old girl. And she had a family photo. And a staff member said, you know, what have you got there? And she said, it's mine. I said, show it to me. Push, shove, with 4 colleagues on the floor, face down, dead, over a family photograph. Now, lest you think we're perfect in Australia, a couple of years ago we saw a CCTV footage of a bowling alley. So it's just looking at the desk and racing in as a young guy, obviously keen to go bowling, bang, 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 bang on the desk. And then somebody else comes in, grabs him, and you see them both going to ground. He could have, you know, whacked his head and been one of those statistics. Interestingly, 2 things. Who reported this? Not the colleague, it was the woman behind the desk, a member of the public who said, that's not right. And, you know, have we become so used to this with our disability services that we didn't think that this was something that shouldn't be done? The other interesting thing was, what was the result? The woman got sacked. But I'd ask the question, had she been trained? Did she know that this wasn't an appropriate response? Maybe they should have sacked the CEO as well, except he owned the business. Now, this is what you've come for. This is our 1 minute of fame. Who can authorise the use of restrictive practices? So in South Australia, we require that the recommendation of the use of a restrictive practice comes from a professional staff member. So in South Australia that might be a DE or a psychologist or OT, and that you know now that you've heard today that there will be a requirement that the Quality and Safeguards Commission will have that there be a positive behaviour support plan. Seclusion, physical restraint, mechanical restraint require the authorisation of the South Australian Civil and Administrative Tribunal, SACAT. Chemical restraint requires the consent of an authorised guardian, that is a guardian who's actually been appointed. And if the person objects to its use and you have to use force or subterfuge to administer that medication, it then requires a specific order from SACAT. And environmental restraint requires the consent of a guardian, and it could be an informal guardian, and Anne will talk a little bit more about that later on. Now, one of the things that I'm finding in the sector is that as we sort of get the message about not wanting to use restrictive practices, there are some people who've not used a restrictive practice at times that they should have. So, you know, someone's going to run out in the road, they've got no road sense, you grab them. You've done that calculation, you know, run out in the road, get killed, grabbed, it's a lesser of 2 things. It's duty of care. We do it instantaneously, but we're actually starting to see some people who are not wanting to do it because they thought they might get into trouble for using restrictive practices. And in Queensland, this reached its low point where a guy who had a very difficult temper, you know, 0 to 100 miles an hour in 2 seconds, and he had a car and a licence, and one day he's yelling and screaming and threatening, and he said, I'm going for a drive, and went into the office to get his keys, and instead of the staff saying, well, actually, no, you're not, they let him drive his car, and the coroner wasn't very impressed with the resultant death. So we have a duty not only to the individual, but to the individual that the person may harm if their behaviour is not checked. So there was a point made this morning that maybe we shouldn't call that a restrictive practice. It's a sort of an emergency response, because in an emergency we abandon the rules and we do the best we can to make sure that the person's safe and that other people are safe. Now, I just want to mention the particular dangers of seclusion. And this has been a particular and sore issue for Aboriginal people in Australia, deaths in custody. We experienced this a few years ago in South Australia, a young man secluded with the approval of SACAT in his bedroom, got his belts, tied them together, made a noose and hanged himself. So when we use seclusion, we need to ensure that it's in a place that's safe, respectful. And the other point I'd make is it's not an alternative to supervision. People continue to need to be supervised when they're being secluded. Our present thinking, we know that the unauthorised use of restrictive practices on people with disabilities is now potentially a crime or a tort, or both. And we also know that the use of restrictive practices is often more for the benefit of organisations than the individual, and often not just for organisations, for disability systems, you know, from the minister down, who was often wanting this particular person jammed into somewhere or other overnight or the next day, not caring greatly about the effects on other people. But most importantly, we now know that with new strategies, we can actually reduce the need for individuals to use the behaviours that require the use of restrictive practices. So we've recently had the national framework, and that now morphs into the work of the Commission, and we've heard about that this morning. I think this is one of the greatest things that has occurred in the last few years, and it's been fantastic to see the work that Paul has led in getting this stuff right. And in Jeffrey Chan, I think we're going to have a person who's not just going to sit there and look at pieces of paper and give things a tick and put them into the filing cabinet. He will be actually ensuring that these plans that people are putting up and the reports on plans that organisations are putting up really do have some effect in reducing the use of restrictive practices. And so in South Australia, some of the things that we're requiring, you know that at the present time we've got the guide on restrictive practices. 1 July it ceases to have any moment. In fact, it doesn't really have any now, other than, you know, it's our indications of, it's a guide, it's best practice. But some of the things from that guide is that if you're looking at using a restrictive practice, there's a process. We need to consider whether there's a legitimate purpose to use it. We need to develop a positive behaviour support plan. That's now no longer something that you can choose to do or not do. It's going to be a part of the arrangements under the Commission. And we need to ensure the appropriate authorisation arrangements. We need to ensure that it's regularly reviewed. Now, I have to say that, you know, you would think that that was pretty obvious, but we had a situation where chemical restraint wasn't reviewed for 18 years, and people had, along the years, gathered up a whole host of new prescriptions and had basically, might have been having 4 or 5 different drugs. And in the review that occurred, they actually got rid of a lot of those without those behaviours reoccurring. And so it's important that there are reviews, and again, that's prescribed in the Commission arrangements. And the other thing that I really think you should do is that when you put in place a restrictive practice, in many instances there will be collateral outcomes to other people. Put a lock on the refrigerator for one person, you've put it on for everyone. So you need to understand that, document it, but most importantly have a strategy to deal with it. So some organisations have got a no questions asked opening the fridge policy. You don't have to explain why you want to go to the fridge. You just say, I'd like the fridge open. The fridge is opened. Other organisations have made bar fridges available. And so it's important that we know the outcomes on other people. There's a slide there on the investigation of less restrictive alternatives. I won't go through it. You can read these things in your leisure. And a slide, what stays the same, and largely everything, which includes that we have the same definitions of restrictive practices, the commitment to, or the requirement to try to reduce and eliminate the use of restrictive practices, and also the authorisation requirements are also unchanged. And Anne's going to talk about a bit of the detail later on. There are some things that change, not with the authorisation processes, and Tracy and Paul have already discussed these, and that is that every person who's subject to a restrictive practice now will have to have a positive behaviour support plan registered with the Commission, and that providers must report on the use of restrictive practices to the Commission. And so they are the two things that will change for providers in South Australia. Now, that's basically, I could stop there, but I can't resist it. Seeing this is my almost last opportunity, I have to just talk about a couple of things that I think can promote good practice. So there are some, I've called them best practice, I think good practice issues that I'd just like to mention. So you may have a man in your service who's got a plan and it says whenever the behaviour gets to this point, PRN medication can be given. So Mary's on duty at 9 o'clock on a Saturday night, the behaviour gets to this point. Does Mary make that decision herself, or does she need to refer it to a duty officer? Some organisations don't have duty officers. It's really important that people know what the rules are. So I've recently been going to some organisations and saying to people, if you have to give PRN medication, what are the rules? And unfortunately, people didn't know. So I think organisations have got some things to do in terms of getting these things up to scratch. The other thing is that it's a really good idea to review your use of restrictive practices. So you'll be reporting stuff. But within your organisation, I think it's a really good idea to keep your policies up to date, review them. And it's also a good idea to look at what's happening at the level of individuals and see if you can do better for them. Now, again, you would have thought that this sort of needn't be said, but unfortunately it does. We need to ensure that organisations have capacity to manage restrictive practices. So everyone who comes into the organisation should have induction on the restrictive practices, what the policies are and what this means actually when they're on the shift. And because these are things that workers may not see very often, it's important they have ongoing refresher training. And most people think that that needs to be done about every 18 months. And now I have to read off the screen because I didn't bring my glasses. Policies and procedures should be understood and implemented at all levels of the organisation. Again, I'm going around at the present time. On my very last day, I'm going to be in Kadina doing some training up there, and I've been asking staff, have you seen your restrictive practices policy? And so far, out of about the 45 people that I've spoken to, 2 people have seen their policy. In the absence of that, what happens is that they actually develop organisational policy at that level. So it doesn't matter what it says up here, policy's being developed here. And sometimes those local policies are not terribly good ones. And we also need to ensure that all staff who are implementing positive behaviour support plans are trained in the specific needs of the client that they're dealing with. So if we're dealing with Richard, we need Richard training. The training that is specific to his needs. The other thing I'd say is that organisations need to support their staff, often dealing with very difficult clients. If we see our staff going on workers' compensation because it was just too hard and too complex and they're burnt out, we haven't supported those staff. We can do it better than that. The Western Australian experience, in fact, I was talking about this morning, one of the people involved was sitting in the audience. 3 organisations supporting about 60 people asked their staff, how many restrictive practices do you use? Answer, fewer than 10. They gave them training, asked them that same question, offering them anonymity and an amnesty, and they identified 132 instances of restrictive practices. I said over 100, but the woman who was here today told me that it was actually 132. So, and just staff understanding that things were restrictive practices, many of these stopped happening, and many of these were in the forbidden territory of things that we shouldn't be doing. We should use the recording and reporting of restrictive practices not just to meet the requirements of the Commission, but this should be used within organisations. So I think the best practice would be every month for the board to have the same information about the use of restrictive practices that goes to the Commission, going to the board. And the board should be asking questions, why aren't you guys getting on top of this? We don't seem to see any improvement. They're the group that is concerned with the governance of the organisation. It's their responsibility to do this. We also need to use it as a way of supporting our staff. You know, the first time I saw an A-grade behaviour meltdown, I didn't know what to do. Many of our staff don't know what to do. You do the best you can. And you can imagine if after that they were told, Mary, look, what you did was a restrictive practice. You know we don't do restrictive practices. That's a disciplinary thing. You're at the first stage of the disciplinary process. Mary will never report another thing, or at least I wouldn't. I can't speak for Mary. If the response is, you know, well done, you stopped a nasty potential situation from occurring. Now here's some other things you might have done in that situation. So there's a cultural thing that we have to develop within our organisations where we use this information to build skills and support staff to do the right thing. And we also use it to monitor trends. Are we actually using a lot more PRN medication in our organisation? The other thing that I think is really important is that all organisations should have a person, a compliance officer I've called it, and you know we're talking also about having a reporting officer. There's no reason why it couldn't be the same person, and you might call it a quality officer, but someone within your organisation. Now let me give you an example. SACAT has said, you know, when Richard gets to this point where he's actually looking like he's going to punch somebody, he can be put in his room for 10 minutes to cool down. And what the compliance officer would do is to say, okay, we've got this authorisation. Now, can we do this safely? Is his room safe? Do the staff know what to do? Is this respectful? Is everything that we need to do this safely, is it all in place? And sign the piece of paper to say that that's what we're doing. I don't think it'd be any defence, for example, if somebody did hang themselves in their room, for you to waive the SACAT authorisation at the coroner and say, we had authorisation to do this. And the coroner had said, and you had a responsibility to do it safely. So the compliance officer is the person who does that in an organisation. A couple of pages about what he should do. And the other thing that I've seen working extremely well is a committee that's been developed to monitor the use of restrictive practices. So every month in this organisation, every person who's subject to a restrictive practice comes towards the committee and they talk about their situation. And I've been involved in one of these on an ongoing basis. They've been fantastic. Oh, you know, Mary, we haven't had to use PRN medication for 6 months. We should talk to her psychiatrist about whether we could take her off that and out of her plan so that we don't have people on restrictive practices that they may not need anymore. And again, there's 3 or 4 pages of stuff about the committee. Now, this is the mob that I've fallen in love with, internal auditors. And you know, when we talk about auditors, we think about money, but in fact, the internal auditors in an organisation can help you with anything where you think there's something that you need to measure or investigate. So, you know, some organisations might have a rule that everybody each year has a plan, and that plan has, you know, got some goals in it. Internal auditors could look at one: has everybody got a plan? Are there goals? Have those goals been achieved? So in this case, the internal auditors and managers and staff established an audit brief that covered all areas of organisational performance in respect to restrictive practices, and they found a considerable lack of knowledge of even the existence of policies and procedures. So not that people didn't know what was in them, they didn't know that they existed. And they found many unauthorised or forbidden restrictive practices, including taking taps handles off of taps. Thanks, Anne. So that people couldn't, run water in the middle of the night. For what reason? Well, because the pain for people would be running water in the middle of the night. And that's only a minor one. There's a whole array of these that, again, many people didn't realise were restrictive practices. And importantly, a significant disconnect between managers and support staff. In terms of policies and procedures, some organisations have got their masthead, 4 words: respect, dignity and choice, or, you can think of any 10 words and put 3 together to make a masthead statement. And this is supposed to be the driving values of the organisation. When you look at the bottom of the organisation, those things are often not being implemented. So I found it very telling that people could use internal audit. And it just makes me think that one of the things that might be missing in the Commission is who's actually going to be doing that audit. You know that in South Australia we have the community visitors who do that. I personally think it's a fantastic service done by volunteers. Many of them old codgers like me that have been through the system and a bit difficult to pull the wool over their eyes, who are going in and having a look at what's occurring. And so I think that's one of the areas that we need to have a look at, where we might develop some capacity to do some auditing of what's occurring. And I think that's it. So until the 30th of June, there's my phone number and my email address if you want to get in touch. And I'm going to now ask Anne Gale, who's our public advocate, just to talk about this in a bit more detail. Thanks, Anne.
Okay. Thanks, Richard. You're almost there. Richard's talked about the authorising body essentially in this state is SACAT. So I'll just go into a bit more detail, but I will do it as succinctly as possible. How many of you interact with SACAT or guardians? A number of you. So you may know this material, and I acknowledge that. But so what I'm going to get through today is sort of relevant legislation in our state, the role of the public advocate very briefly. In terms of decision making, that's where I'm going to try and drill down to who can make decisions about what. So informal arrangements, role of SACAT, guardianship orders, and then touching on the highest level of restrictive practices. So 4 key pieces of legislation that operate in this area that you may be familiar with: the SACAT legislation, the Guardianship Administration Act, Mental Health Act, and Consent to Medical Treatment and Palliative Care Act. Maybe a couple of others, but they're probably the main ones that deal with authority and decision making. So just touching on the public advocate is appointed or established under the Guardianship Administration Act. And really what I want to draw out here is not go through all of those functions, but in this conversation is about decision making and consent. So it's being a guardian of last resort. So acting as guardian of last resort. So we are only appointed by SACAT when there's no one else in someone's life, or there's a lot of conflict around that person and there's no one else who can sort of make decisions with and for a person. And I always say with and for a person because whilst we're appointed substitute decision maker, we do try and, our goal is to respect the person's wishes. The principles in the Act talk about paramount to a decision is the person's past wishes, so what they would have wanted, alongside their current wishes, and also taking into account care and protection. We don't talk best interest in South Australia. Our legislation's about what would the person have wanted standing in their shoes. So we try and make decisions with people as much as possible. Oh, I've gone the wrong way. I know I haven't. But before we get appointed, so last resort, informal arrangements are sought to be preserved, and SACAT always tries to do that. And when they are operating, informal arrangements, decisions can be made in relation to in-home services. So a person with decision-making incapacity or an impairment can be supported alongside a family member or carer to make decisions about care for community support, if that person does not object, and similarly about where that person might live, so long as that person does not object. And then health and medical treatment decisions can be made. Sometimes they're outlined in an advanced care directive if a person has made that before they've lost capacity. But there can be decisions made by a person responsible also under the Consent to Medical Treatment and Palliative Care Act. And there's a hierarchy in that Act that is useful to understand. So guardian is the highest level where it's a formal arrangement appointed by SACAT. Then the next level is a prescribed relative with a close and continuing relationship. And that's the new kind of close and continuing relationship that's been introduced in recent years to replace next of kin. So that close and continuing relationship can be a spouse or a domestic partner. It can be an adult related by blood or marriage or adoption. It recognises Aboriginal and Torres Strait Islander kinship and marriage relationships. Can also be an adult friend with a close and continuing relationship, so they don't have to be related. It can even be a neighbour. And it can be an adult charged with overseeing ongoing day-to-day supervision. So there are a range of people who can act as a person responsible. And there's no need to seek a guardianship order if they are working well, but they do break down disagreements in families, in relationships, disagreements about the decision, disagreements between the person the decision's being made about and the decision maker. And when it breaks down, that's when you might apply to SACAT. You might apply for a guardianship order. It could be a full or a limited or a joint order, and it might include restrictive practices. So I'll come to that, but they are two separate applications. So as I said, restrictive practices, and now I'm referring to Section 32, which I'll go into a bit more detail, of the Guardianship Administration Act cannot be approved by informal arrangements and hence go to SACAT. So SACAT can make these appointments. They can appoint a guardian to make decisions about accommodation, health and lifestyle, and I'll talk about them in a minute. They might also appoint an administrator for funds, but that's someone different, that's the public trustee. They might agree to certain medical treatment. SACAT can only make decisions about sterilisation, for example. That can't be delegated to a guardian. They can grant those special powers that I'll talk about in just a moment. And they can also, in terms of mental health, they might approve inpatient treatment orders or community treatment orders that are time limited, recommended by psychiatrists. But again, they can include restrictive practices. So in terms of being appointed a guardian, we can make substitute decisions. That could be a private guardian, that could be a family member or someone that the person knows well, or it could be the public advocate. We can make decisions about accommodation, health and lifestyle. And lifestyle is quite a broad category. It can include access arrangements between family or friends. If there's conflict in the family, we might make a decision about who that person can see and when. We might also make decisions about someone's use of a restrictive practice. And the example I've used in these presentations has been about the use of like a motorised vehicle, like a gopher scooter, and that being highly powered, person was coping fine, they start to have risky behaviours, they're starting to go on the road, the service provider then wants to shut down the motorised part of it, and we say, no, let's have a think. We work through it. We don't assume and automatically give authority for that restriction on that person. We say, let's reduce the power on it and let's make sure there's someone with them whenever they go out. And, you know, that under NDIS might require more money being in place because previously they could go out on their own, but now they need someone to go with them. And so we work through that. We don't just automatically approve them. But under lifestyle, we can approve those sorts of practices. And if a restrictive practice is approved, it requires a positive behaviour support plan. And the other example I've been giving, say a health decision, Richard talked about the frozen chicken. We might agree that it's not appropriate for someone to be eating, going to the fridge and getting those things out, so we might, under a health decision, approve that. And it's important that service providers get that authority from the guardian. We do require a positive behaviour support plan, but to be fair, we very rarely get them. And so sometimes we are, and because it's not legislated in South Australia, we are approving some practices without these plans or seeing these plans, and that puts us in a place of discomfort. So we are quite pleased at the direction that the Commission's moving in. So I just want to talk about these special powers. So Section 32, are you familiar with Section 32? Yep, few nods, okay. So there's three things mainly that SACAT can approve, which is where someone lives. So they can direct a person as to where someone lives. They can also delegate that to a guardian to direct a person. So there's two parts to that. In terms of the second thing, which is detaining a person, guardian can't approve that. That comes from SACAT. And the third one about using force or coercion needs to come from SACAT, and the doctors make that decision about to what extent they'll use restrictive practices. So we've got that clarity now. And they must only do that to ensure proper medical or dental treatment, day-to-day care, the well-being of the person is paramount, and only if there is a health or safety risk to the person themselves or to others. And SACAT will require evidence. They won't just approve these things, they will require evidence to demonstrate the need for those powers because of the extent to which they do restrict people and impact on their human rights. So that slide's pretty much saying the same thing. Last resort for Section 32 powers. And as I've said, we should only approve these powers or the use of these powers when a positive behaviour support plan exists. And now we will see that requirement under the Quality and Safeguarding Commission, and I think that's a positive step forward. I've been talking with SACAT about how they might address that in its future processes. So currently, as you'd know, to apply for guardianship, under their rules, which is a legal requirement, you must submit medical reports. And I'm sort of suggesting to them to think about, well, why don't you at that point in time require the positive behaviour support plan so that it's considered in your deliberations, and then it can automatically then also be given to the Quality Safeguarding Commission. We haven't quite landed that yet, so we'll see what SACAT determine in the coming few weeks, hopefully, because it is imminent. And of course, we've been working with them to develop, information sharing. So what we hope, we attended a workshop last week, and we're hoping that things like, say, the guardianship order can be automatically shared with the Quality Safeguarding Commission, that we can minimise the amount of information that service providers have to sort of send around the system. But that's early days, and we're just working that through. If you have any questions, there's plenty of ways that you can contact us. We have information services and fact sheets. And the last thing I just want to show you is a private guardians manual we developed and launched last November, which is targeted at private guardians, because whilst we might talk about restrictive practices in service provider land, families also do make a lot of decisions and carry out a lot of practices. And this is a plain English guide as well as easy read with pictures. They're not short, but it's an attempt to say this is your responsibility. And whilst it says it's for private guardians, it's actually useful for anyone to understand the law. And I'm sure you people probably do, but it's a useful guide, and I just thought I'd highlight that for you to reference if need at any point. And that's really the detail that I think many of you already knew, so thank you for listening. But now you've got the chance to ask questions of both Richard and I, and even though he says he's got poor taste in his fashion, he does have the fanciest socks I've ever known. Go on, show them. And yesterday he had sunflowers. Yeah, and they weren't matching, but they were still full of sunflowers, so he's quite a colourful character. And your chance... Yeah, he does indeed, so well done. So yes, opportunity to ask us both questions, but I will be around in 2 weeks' time, but this man will be in a private capacity then, so take your chance.
Or any subsequent questions for Paul and Tracy in light of what Anne and Richard have talked about? Yeah.
I'm just aware that SACAT is going to be inundated in the coming weeks, I think, as people become increasingly aware of their obligations. I'm just wondering how they're placed for handling the workflow that's likely to be generated.
We have a constant conversation with SACAT about probably two things. One is the rate, whether there'll be an increase in application orders for guardianship, which we're hoping the NDIS won't generate that. And they have been very strong in saying we will not appoint a guardian just because of the NDIS. If good decision making is happening to date, why would we do this? But we also know that there are things like signing of leases. So there are some different requirements that are starting to come through. In terms of positive behaviour support plans, is that what your particular restrictive practices you think might generate some?
Well, I think both positive behaviour support plans, but I'm also thinking about participants that I currently support who are generally being supported by families, often with very, so say for example, families employing their own staff directly. So these are staff who are not aware of their obligations under the Commission, so they're not actually under an agency, which I think is a very dangerous practice. But yeah, we're going to increasingly these families are now becoming aware that, oh, this is not going to be a sustainable arrangement, so they're panicking, they're thinking they have to source other service providers, and recognising that they probably will need to be using, getting authorisation for restrictive practices that they hadn't previously been aware was considered restrictive.
Yeah. Look, it's a really good point. SACAT have, we've tried to do a lot of pre-planning to share names of people under guardianship that, you know, might need a review of their guardianship order. We've tried to get a sense of who out there might need an order in the future. I think you're highlighting those family arrangements that we can't quantify. We don't know. Out of all the planning we've been doing for the last 18 months, we don't know that number because they're not on our radar now. And, you know, SACAT is a little bit nervous about what it might bring, but they will also say, well, but yeah, for restrictive practices, they'll have to acknowledge that and hear it. So they don't have any more money than they had yesterday, so there could be an impact on hearing times if there is a bit of a rush. Yep. It really depends on whether things trickle through. Although that said, and we do know that the NDIA has about another 4,000 to 6,000 people to get into the scheme that they're behind on, and we are anticipating a bit of a ramp up. So I've been in liaison with NDIA about, can you give me a plan, can you tell me what to expect? So not only SACAT, but what I need to do, because I've got about 300 people, I expect about 600 people to go into the scheme who are under adult guardianship orders, who of which only 40 have plans. So we know that it's coming in the next few months. So we'll just have to cope. We've tried to plan as much as we can, but we'll just have to keep monitoring it and try and resolve issues as they come along. And, you know, if you're aware of something, just please come forward, because the more we can try and plan for things, the better. Yeah.
I think the other point I'd just make, outside of the arrangements with SACAT, many families are big ticket users of restrictive practices. You can't blame them. I mean, it's often the way that they've coped because, you know, like when I was at IDSC, wasn't giving them enough support to do other things. Many families are really committed to those restrictive practices. Many families want the agency that takes over the responsibility for providing accommodation to continue to provide to do those restrictive practices. And organisations are saying, no, we can't do them. We've got a process we have to go through. I suspect that families will start to try to find how they can fly beneath the radar, you know, by basically setting up your own service and using restrictive practices. I understand that you won't be able to be an unregistered provider in the new arrangements, but I'm just thinking that families will try to probably find ways in which they can, you know, stay out of the clutches of the Commission. And continue to use the restrictive practices that they want to.
I agree.
I might just add that it's very hard to plan for this area because one doesn't really know what's out there at the moment. So we have in South Australia, and this varies from state to state as well, of course, but so in South Australia we have, you know, some visibility of the type of people that come through SACAT and so forth, but how many people out there who are using restrictive practices who you know, don't have any authorisation, or it's just a sort of a parent-child or parent-adult-child kind of relationship? I mean, we just don't know. So it's actually been very hard to plan for what the ramp-up might be which is why when we were talking earlier, we talked about transition arrangements and gradually moving to this, because we recognise there is going to have to be a phasing in of this. It can't all happen on day one. And it wouldn't anyway, I suspect, because I think it'll be a gradual awareness for some people that, oh, we're actually using a restrictive practice. Everyone isn't going to realise that on day one. As the best practice education happens, hopefully more of that will surface and gradually be brought, the standards will be lifted over time. But it really is very hard to tell who's out there, so we don't know what the demand is, in a sense.
And if there is any sense, I guess I'm repeating myself a bit, of if there's 10 people that you're aware of that need to have some form, come forward and talk to the registry at SACA or to us at OPA, because we have, like where we've known in group homes where people have been there for many years but needed a review of their order, we did an arrangement with SACAT. They did them on the books or they'd go out to the home. So there's ways, which is more streamlined for them because they're already pushed, for timelines. So if there's any way of planning ahead, come forth and we'll try and see what we can do, rather than the ad hoc kind of crisis type situation that we can avoid if possible.
Does anyone else have a question? Or
Just as a provider, after today, obviously, I go away and go, okay, I've got some things to look at. So I'm expecting that we're going to need to do quite a few behaviour support plans and the resultant restrictive practice. Now, is the Commission, and probably, I know you can't answer for the agency, but are you expecting that there's going to be an increase in the volume of what currently is, and like quite a large increase?
Yeah, yes is a simple answer to that. I mean, I suspect there's a whole lot of practices going out there, and as I say, we know this more anecdotally than kind of have facts and figures, that probably there are a whole lot of practices going out there that people don't even realise are restrictive practices, so therefore they're not seeking authorisation or have plans in place. Or two, they might have authorisation but they don't actually have a behaviour support plan in place, as we've talked about up here. So all of that, I think, is going to lead to increased demand for behaviour support providers, for behaviour support plans, and thus a demand on the NDIA and to provide funding for these things, because I suspect that also the NDIA probably isn't aware of some of these things and they're not in people's plans at the moment. And so I do expect that it will create greater demand than is recognised at the moment. As I said, we're not sure exactly what that demand will be, and that'll put pressure on the it's a fairly thin market, we're told, in the behaviour support practitioner side of things. So suddenly implementing providers like yourself go, oh my God, we need these behaviour support plans. Again, we're not sure, whether there'll be enough behaviour support practitioners to assist in that, even assuming the NDIA gets their act together and funds it and all those other things. So, it's a bit of an unknown. That's why I think we went over it fairly briefly, but we've kind of got those transition kind of arrangements in place. The whole idea of those is to try and phase it out and make it a bit smoother. But nevertheless, until we actually kind of get a bit more experience around what that volume of unmet need is, we're not really going to know. And we may have to well adjust that phasing arrangement depending on what that unmet need is and whether there's enough behaviour support practitioners and the system can cope with the increased demand.
I guess that's just the other point to make, is the phasing arrangement for particular service providers hasn't been decided yet because of that. So we'll be able to decide those things on all the different factors you've mentioned already as well. So.
Yep, I'll go there and then to you.
Hi, I look after a number of group homes at the moment, and I guess for me the biggest thing through staying the NDIS process is that I've been involved in dealing with SACAT a lot more at the moment, because there's a few areas that have been, I've identified about 5 clients alone that we actually need to go through the process. So, and I haven't started. So I think that's going to be my concern, is that I'm going to be doing a lot at the moment in putting things in place because of previous practices.
And are you working in the not-for-profit sector? You're not, obviously not in the government group home system?
No.
No. You,
So,
not for
so-
profit?
not for profit, yeah.
Yeah. And what we were able to do was work with the government service provider and figure out their clients and match them with our clients, and then there would be new people, but we were able to do that. We weren't able to get the same data from the non-government sector, so I'm not surprised to hear what you're saying. And that, yeah. But if you do find you've got big numbers and you want to design a process with SACAT, as I said, do come forward because we may be able to assist in that. They might do things on the books. It really depends on the person's circumstances. They don't like to do things on the books because they really like to have the person involved, but they also recognise the stress and trauma of maybe coming to a hearing if it's not necessary. So each circumstance needs to look at by itself, but they will be, I shouldn't speak for the executive member myself, but I've seen examples of where the tribunal has tried to accommodate. So yeah, if it's you've got 5 and only 5, but if you've got 50, then maybe you need to come and talk. Yeah, well, maybe come and talk to us. We'll see what we can do to assist in a process that's simplest and easiest for clients as well as the agency and SACAT.
Paul, just a question for you, if I can. In relation, I'm assuming that it's okay for behaviour support therapists and implementing providers to be from the same organisation. And if that assumption is correct, is there guidelines around needing to provide evidence of choice that customers have made in that process, etc.?
Yeah, it's a very good question. And I don't think we've actually kind of finalised the policy around this, to be honest. I know that the NDIA are very keen on trying to sort of weed out any perceived conflicts of interest, and clearly we've got the behaviour support practitioner in the same organisation as the implementing provider. I guess that could be a perceived conflict of interest. So I think in a general sense the policy position would be we need to try and address that perceived conflict of interest. Now that might be at one end, it might be by ensuring that the behaviour support practitioner is kind of not developing plans for their own organisation. But at a less kind of drastic level, it might be just ensuring that the organisation has in place kind of clear fences between the behaviour support function and the other functions, the implementing side of things, and evidence, as you say, that the person's needs have been taken into account and independently kind of considered aside from the implementing provider's requirements. But that's kind of just my off the top of the head thinking around what people in policy land are generally talking about there. So we're aware of the issue, but it's kind of, we haven't developed the operational kind of policy, I guess, to give you guidance on exactly what to do. I mean, I guess I'd be saying that, and this will probably be up to Jeffrey Chan when he comes in to some extent, as well as talking to the NDIA as kind of one of those cross-cutting issues. All I'd be saying is if I was an organisation in that situation, I'd be thinking about how can I demonstrate that the behaviour support function is operating independently of the implementing function and try and set that up as best you can in your organisation at the moment. But yeah, I think it is a vexed kind of question. And this has come up in a whole range of areas in the NDIA, like being able to be a planner, not a planner, a plan manager, support coordinator, and also being a provider. Can you have them? And the answer to that's no at the moment from the NDIA, although there are a few exceptions to that around the country where that is the case, particularly in sort of remote and where it's kind of really hard to get, that separation happening. So I think that the general tendency is to try and make sure there's an independence there. But yeah, no specific policy in place yet.
And just while I've got the mic, Anne, can I just ask a bit of a side question? Are you able to clarify the OPA's position on signing NDIS service agreements to enable support providers to provide support where there's a guardianship order in place?
Okay, yeah. Service agreements. Initially, when we started out, there was an issue around service agreements. We followed sort of Victorian lead, who were saying there's clauses in the original service agreements that had things about ensuring certain behaviours would be complied with, etc. And as Guardian, we were informed that's not appropriate for us we can't agree that a person will behave in a certain way. So we couldn't accept that liability. So we designed then a letter to say we accept this service agreement. It's fair to say that as I'm talking, this is a bit of a moving feast and we need to revisit sort of our position on that. Some other jurisdictions are saying, well, you don't need to sign the service agreement at all. So I think we are in a little bit of a moving landscape because the service agreements are between the client and, the service provider. Whether we have to sign them or not doesn't prevent the services from happening. So we've just got to work out a little bit more. So that our position was we will send a letter to say we approve all of these things around the service agreement. Please proceed. That's probably what my office is still doing at this point in time, but I'm just alluding to the fact that we know it's changing and we need to land a final position on it. And we're working that through with the NDIA as well.
I think, like all things, we're happy to go on a journey with everyone.
Yes. Because, of course, at the end of the day, what we don't want to do is get stuck on, I'm not signing, and the client doesn't get any service. So that's, the most important thing. But then you ask a lawyer, sometimes sorry if there's any lawyers in the room, but, then they, you don't sign it for this reason. But we've got to be pragmatic as well. So we're trying to find that balance.
Can I just clarify one thing I maybe missed earlier for you guys? You mentioned that as a service provider, when I have restricted practices in my service, I have to be a registered provider. But if my client is plan managed or self-managing in some way through the family, can they have a behaviour therapist, someone who writes the plan and works with them, who is not registered?
No is the answer. Well, under the arrangements, legally no, and they can't self-manage that part of their plan. So the behaviour support part of a plan, they won't be able to 100% self-manage. That will have to be managed by the NDIA as our sort of legislation and everything currently stands.
So will it be separate?
If it has restrictive. Yeah, I think that was the premise of your question.
So on their plan, if they have the allied health section in there where it has all their things in there, the behaviour support stuff will be separate from that?
That's right. So we are talking here about specialist behaviour support 110, and we're talking about restrictive practices. So both of those things have got to be there in the plan for the requirement for an implementing provider to be a registered provider. So you can be an implementing provider of general behaviour support, or what I might call small b and small S behaviour support. So any therapist, say, who's involved delivering therapies might have some element of small b and small s behaviour support, say a skilling up of somebody or something like that. We're not talking about those. We're talking about the complex behaviours of concern where there's therefore a need for a professional full-blown behaviour support plan, which is delivered by Specialist 110. And two, as far as the implementing provider is concerned, it's also got to have the restrictive practice in it. So they're the two things that make it a requirement for the implementing provider to be registered. If you were just implementing a behaviour support plan that didn't have any restrictive practices in it, there's no need. An unregistered provider can deliver a behaviour support plan. That's not a question. It's only if there's a restrictive practice in it that registration requirement comes about.
So say there's a psychiatrist now who deals with them and has been prescribing the practice for many years now. They could still prescribe, but they can't be the person that does the plan.
Well, possibly. I think that's a bit open. They potentially, if they're registered, basically the person who can do the plan is somebody who's registered for Specialist 110. Now, often a psychiatrist might have, prescribed some kind of chemical restraint. That would have to be a part of the plan, and the behaviour support practitioner would work with the psychiatrist in that case to work out, well, is that chemical restraint, is that a chemical restraint, or is it actually to treat whatever it might be that the person has? So the question of whether it's therapeutic or not, if it's actually not therapeutic, so it is a restrictive practice, then it would have to go in that behaviour support plan. And as we've talked about, there would need to be some kind of strategy to work out alternatives to that chemical restraint if it was just purely used for that controlling behaviours, for example. So there'd have to be a restrictive practice kind of reduction plan over time to look for alternatives to that. But the behaviour support practitioner would have to work with the psychiatrist around that, because the psychiatrist is the one who's prescribing it in that situation. Does that make sense?
Yeah. Trying to get that choice and control, and keeping things normal for the clients who've had these things in place for many years, and have people that know them, not having to retell their story over and over again to different people. That sort of thing.
Yeah, look, it's a difficult area. I think, as Richard said, there are cases where there's been that kind of restrictive practice in place for 18 years and nobody's questioned it up until now. So I think any of those cases, practicality and common sense and kind of actually working on the specific case and an appropriate strategy for the specific case, always has to win the day rather than any kind of, blanket solution. But certainly there'd still be an expectation in, say, that case, there'd at least have to be a questioning of, well, do we need to continue this restrictive practice, and what are the alternatives to that? And that's kind of what the behaviour support practitioner would facilitate in those circumstances. But it'd have to be a sensible, workable solution that's in the best interests of the person with a disability. Yeah. Well, looks like we're just about done then. Thank you very much for coming. I hope some of the information we gave you, deepened your understanding of what's likely to be coming up. And by all means, I'm sure anybody who has spoken today is more than happy to continue the conversation if you want to get in contact with us if other issues emerge. And keep on the lookout on our website for not just the information we've provided today, but as the kind of questions, very good questions you've asked, where we haven't actually had like the policy solution nailed down. Hopefully over time, as the Commission staff get on board, we'll start getting better answers to some of those more complex questions you've asked and more operational questions. So thank you very much, everyone, for coming.